Hello, everyone. Welcome. It is 12:15, so we're going to get started right on time. My name is Marcy Gutierrez, and I'm a partner here with the law firm of Hire Gutierrez, and I've been doing special education law ever since the year 2001, a long time ago, former teacher. But welcome everyone to our very first Lunch and Learn, our virtual Lunch and Learn. We decided that we wanted to start doing these virtual Lunch and Learns every couple of months or so, just to make sure that we are all staying up to date with the most recent decisions that are issued by the Office of Administrative Hearings, which is OAH. That is our state agency that presides over due process hearings. Some of you may know this, but for those of you that don't, at the end of every month, OAH distributes written copies or online copies of all of its decisions that were rendered for that particular month. So I think for example, the month of September, there was only one decision that month. But for the month of October, for the end of October, there were 8 decisions that OAH issued. And those are the 8 decisions that we're going to be talking about in today's Lunch and Learn. The 8 cases that we're going to cover today range in issues from appropriate assessments and IEEs to full-blown FAPE and LRE disagreements to autism eligibility, compensatory education, and we also have a case on the statute of limitations. With 8 decisions to cover over the next half hour, this gives us about 2 to 3 minutes just to highlight the cases. And hopefully we have some time at the end of our presentation today to answer some questions. If you have questions during the presentation, please feel free to use the chat box and we will try, time permitting, to answer some of these questions. I'm sure most of you know that OAH decisions are not binding. And what this means is that the way a judge, administrative law judge, rules in one of our OAH cases doesn't mean that another administrative law judge at OAH has to rule the same way. But however, I think it's relevant to look at our OAH cases because this would be our first level of litigation if a parent filed a due process complaint against us. So we always like to be very aware of which judges are rendering decisions in favor of school districts, against school districts, et cetera. And so we hope today's Lunch and Learn will be useful to you in staying up to date on these cases. Let's go ahead and dive right into it. Tillman's going to talk about the first few cases here.
Yeah, good afternoon, everybody. Thanks for joining us on our first Lunch with Legal webinar. So my name is Tillman Hire. I'm one of the founding partners at Hire Gutierrez. The first case I wanted to talk about from the October batch was this one, Student versus Capistrano Unified. And so this was kind of the kitchen sink case. It was a 106-page decision. There was basically everything at issue in the last 2 years of the student's education. So I just wanted to focus on one particular element here that I found particularly interesting. The student called 2 experts to try to pick apart the district's assessment. Part of what was happening here is that the district filed to defend its assessment. And so one of them was a school psychologist who had a PhD, who was a school psychologist for 6 years and now in private practice. The other one was an LEP who had a doctorate in psychology and was also a professor in a teaching credential program at the master's level. So 2 highly qualified people that the student hired, and so as expert witnesses. And so I think this case is interesting to look at the arguments they raised and what OAH said. The first argument that the experts had for student was that it was inappropriate for the district to use 2 different academic measures. So Capistrano used the Woodcock-Johnson 4 to assess writing and math, and then the Wyatt for the other academic areas. And OAH said, putting aside what is best practice or not, that using those 2 tools, 2 different tools, did not deprive the IEP team of critical information. So this is a positive conclusion. There's deference to the choice of assessment tools that the district chose to use. The second claim that the experts had against the district's assessment is that the district should have administered 2 supplemental tests as part of the BRE VMI. And so the broader context of this is this was a student with dyslexia, and the assessor said that the 2 supplemental tests needed to be used to determine whether student's dyslexia was the orthographic or the surface subtype. OAH disagreed with that and found that the BRE VMI provided enough information to the team. And this sort of reminds me of that case from the Ninth Circuit from a couple of years ago Issaquah versus Crofts, where the Ninth Circuit concluded that the district didn't even need to diagnose the student with dyslexia. Of course, we might want to do that as a best practice, but the Ninth Circuit is just talking about what the bare minimum was. And so this kind of goes in that same vein here, that the BRE-VMI supplemental subtest did not need to be used, and there did not need to be a conclusion of what type of dyslexia the student had. The next piece here was the SLD analysis, what was used to determine significant discrepancy. And so one of the experts said that the SLD analysis should have relied on full scale IQ and not fluid reasoning. And so for this student, the general abilities index and the fluid reasoning was scored at a 94. FSIQ was at an 84. And so the school psych's position was that the FSIQ actually underestimated the student's cognitive ability, likely because of the increased reliance on processing scores. And so OAH agreed with the school psychologist that the FSIQ underestimated the student's cognitive ability. And so OAH said the school psychologist was correct to use fluid reasoning as part of the SLD analysis. Last point, OAH said the report did not need to specify what sort of dyslexia the student had. And again, like I mentioned, this was consistent with Ninth Circuit precedent that technically reports don't even need to say a student has dyslexia. It just needs to have an opinion on what eligibility categories student qualifies for. And so these are the 4 points. Ultimately, the district prevailed on all issues related to their assessment. And it's really interesting kind of to see here the nitty-gritty of the arguments and how OAH analyzed them. The big picture in this case is kind of interesting. So the parent sought reimbursement for a private school with students with dyslexia, which is a pretty normal thing. But where it really gets a little sideways is that this private school was in Kentucky. And so it turns out that there were only 20 hours of comp ed ordered against the district for some goals in the March 2023 IEP, because it turns out for the last 2 school years, the family had actually been living in Kentucky. And so there was no liability for the school district for that period because they weren't residents. So the next case here is Parents versus Saugus Unified School District. So we have a first grade student qualified under OHI for ADHD. And there were 8 issues raised. 7 of these issues had to do with the parent's objection to the disciplinary interventions that Saugus used. And so, and the 8th issue was about parental participation in the IEP process. And Saugus prevailed on all issues, but I think there's still kind of a lesson to be told in this case about how litigation can work sometimes. And so this student, at least in my sense, didn't have a really intensive background in terms of student discipline. So on October 29th, he got a warning for using bad language. On February 10th, he got a warning and kind of a restorative practice for punching another student on the playground. On February 25th, he touched another student on the bottom. He got a warning and a conference for that. Where the parent really took objection is that in the late part of the school year in June, the student started making comments about his para's weight, calling her fat, things like that. And so after a number of these comments, the paraeducator reported it to the teacher. The teacher sent him to the office. And so he missed 15 minutes of one lunch period because he was talking to the school principal about how his comments were hurtful. And then he missed the whole next lunch period because he continued this conversation with the school principal and wrote an apology letter to the para that he had offended. So to me, this seems like a very, very reasonable disciplinary approach, and yet there was this huge objection to it. The parent took objection because she said there needed to be a manifestation determination. This was a manifestation of disability, all of these things, and Saugus prevailed on every single issue. And the key quote here that is to me the takeaway is that the issue of a connection between the disabling condition and school discipline arises once there's been a change in placement. And change in placement, of course, is a term of art. We're talking about that 10-day line that we use for manifestation determinations. Another fact too, the parent accused the team of recording an SST meeting, and the judge said there was just simply no proof of that. And so to me, like, I look at this case and it seems like Saugus had a very reasonable approach to student discipline. There were no suspensions. He missed a lunch period and a half for saying some hurtful comments to the paraeducators that, there were restorative practices used, all these things. And yet this case went to due process hearing. And so it just goes to show that sometimes if you have a complaint, if you have a hearing, if you have a case, there's sometimes nothing you can do, because I think Saugus really acted very reasonably in these circumstances. Our third case here today is Parent versus Invictus Leadership Academy. And so this case was, I think, a sigh of relief for me. You might remember 1 or 2 years ago, we talked about the JR, the Perez versus Ventura unified litigation about the statute of limitations. And so what happened in the Perez case, so if you know the statute of limitations, we know this as the 2-year rule, but you get to go beyond the 2 years in litigating if there is a misrepresentation or if a district has withheld information from the parent. And so in the Perez case, the Central District, a federal court, overturned OAH and said in a nutshell that because the district had represented its assessment as thorough when in fact it was not, that was considered a misrepresentation, and the parent could go back years and years and years to litigate things well beyond the 2-year statute of limitations. And ultimately Perez resulted in a huge remedies award, a huge financial cost, I'm sure, in attorney's fees as well to that district. And so it put us school district folks a little on edge as to like, what actually does it mean to misrepresent something, and what is the threshold for a misrepresentation? And so the issue got brought up again in Invictus, and the district, this charter academy prevailed here. And so the parent alleged that Invictus misrepresented 2023 assessments, which were done online, as valid, when in fact they were not, and also withheld procedural safeguards and other documents. And so the only issues raised in Invictus were those beyond the 2-year statute of limitations. So OAH didn't fully touch the substance of the parent's claims, because they found that there was not actually a misrepresentation that would even allow the parent to go beyond the 2 years. And what really is remarkable here to me is that OAH treated whether the assessments were compliant as a substantive issue, and not one of these quote unquote misrepresentations that would allow the parent to go beyond the 2 years. And so we're all wondering on the school district side, how is Perez going to be interpreted? What is the implication going to be for future statute of limitations claims? Well, this Invictus case to me is a little bit of an indication that maybe the status quo actually won't radically change, and we won't have to deal with a lot of due process complaints that go back 3, 4, 5, 6, 7 years. But again, like Marcy said, OAH cases are not binding. So this is one case, the other case might go in the next direction. So let's go to our next case here, Whittier Union School District.
Hi, everyone. My name is Michelle Breitmeyer. I am an associate here at Heyer Gutierrez Law Firm. I'm a former teacher and administrator. I'm going to go through 2 cases today. The first one is Whittier Union School District versus Parent. This was a district filed case, and it was filed to determine whether the assessments that Whittier conducted were appropriate, and then student wouldn't be entitled to the IEE that they're seeking. The parent contends that the assessments were defective only because the district relied on those assessments to offer a change in placement. The student, he had multiple disabilities, he had intellectual disabilities, he was reliant on adults for almost all aspects of his life, from eating to bathing to toileting. He was completely nonverbal, and he communicated through grunts and eye movements. So he was at a home instruction placement, and the district, based off the assessments, changed the placement to an on-site instruction. The ALJ determined that all of the assessors were trained and knowledgeable, and that their assessments consisted of a lot of factors: records reviews, interviews with parents and teachers, many observations over long periods of time, formal and informal assessments. The student did struggle with the formal assessments, and the district was unable to complete a lot of them based off of his nonverbal status. But they relied mostly on the interviews with the teacher and with the parent. They relied on the records reviews, the observations, and rating scales. The parent's testimony centered around the placement recommendation, but had no testimony about the actual concerns regarding the assessments. They were unable to articulate what their disagreement with the assessments were, other than the change in placement. They did not express any concerns regarding the assessment process or the results of the assessments. The district also conducted an AT assessment, and the parent disagreed with this assessment for the same reasons, and also that they offered a low-tech AT device instead of a high-tech device. So during the assessments, the district trialed both high-tech and low-tech, but the student showed difficulty with the high-tech devices. He was very successful with the low-tech, such as flashcards and pictures. And ultimately, the district prevailed on both assessments because the student decided that the student was not entitled to IEEs based off of the assessments that the district conducted. The next one is Sebastopol Independent Charter. This was a parent filed case. In this one, the student was in 8th grade and he qualified for special education under SLD and OHI. He had a diagnosis of autism through his medical insurance. The district performed their assessments and the parent contended that the district denied student FAPE when the district did not include autism as one of his eligibility categories. The parent felt that student lacked friendship skills and that his friendships were superficial and not like the close friendships she had experienced. So she was worried about his academics, his school behavior under his autism diagnosis. But the district contended that student was not eligible under autism because he did not exhibit any of the characteristics associated with autism during his assessment that would adversely affect his performance in school. During the observations and interviews, they found that he was sociable, he participated in his class discussions, he raised his hand, he was very active, and he was actually performing at grade level with accommodations. The assessments revealed that the student did not display any communication defects, he did not exhibit any repetitive behaviors or any sensory sensitivities. So the assessor concluded that the student did not meet the eligibility category for autism because he did not demonstrate an impaired social interaction in pragmatic language or social interactions to a significant degree. And I thought that the final quote from the ALJ on this, there were a lot of issues in this case, it was 150 pages, but on this issue, the ALJ actually said, as long as a child remains eligible for special education and related services, the IDEA does not require that the child be placed in a particular disability category. And then they cited the U.S. Department of Education when they said students have an entitlement, their entitlement is not to a specific disability classification or label, but just to FAPE. So Sebastopol prevailed on this case.
Okay, this is Simi Valley versus students. That when we see the school district named first, that means it is the school district that filed for due process. This case has to do with assessment plans and IEEs, and I don't love this case, by the way. It's a bad case for us. And I'm in fact going to be emailing the SACE people to let them know about this case. This due process hearing only lasted for 2 days, and it was presided over by Administrative Law Judge Jeannie Min. As I mentioned, we always like to see what kinds of judges are issuing what kinds of decisions. This complaint, as I mentioned, was filed by Simi Valley, and it was filed in August of 2025. Parent did not even have an attorney. They were self-represented at the hearing, and yet the school district, who was represented by attorneys, still lost the case. At the time of the hearing, the student was 10 years old and in the 5th grade and was previously eligible for special education under the category speech and language impairment, but had been exited from special education in May of 2019, excuse me. There was one issue in the case, which is Simi Valley's multidisciplinary assessment legally appropriate such that parent is not entitled to an IEE? Right? Whenever we have an IE request, we have to file for due process or we have to fund the IE. Well, Simi Valley had assessed the kiddo in May of 2025, and then a month later, parent asked for an IEE. Parent wanted an IE in cognitive and executive functioning, attention processing, social pragmatic communication, and meta-linguistics, as well as emotional and behavior regulation. Well, a few days after that, Simi Valley gave a prior written notice declining to fund the IE in those areas and obviously had to file for due process to prove its assessment was appropriate. The judge in this case did not even look at the assessments conducted by Simi Valley. Simi Valley lost the case because of the assessment plan and a regulation that I don't think I was aware of until this case came out. So instead of starting the case by looking at the assessments, the judge went back in time and talked about the fact that Simi Valley had assessed the student in May of 2025. And then after that January 2025 assessment, The parent wanted an IE right away. Simi Valley said, let us do some additional assessments. And that's when they developed the assessment plan for the assessment that they went to hearing on. The reason they lost this case, the reason that Simi Valley lost on their assessment plan, even though parent consented the assessment plan, the assessments were done, according to the California Code of Regulations, Title V, Section 3022, which the judge cited, an assessment plan must contain a description of any recent assessments that were conducted. So the judge said that by failing to, that their assessment plan didn't have any kind of discussion about the fact that they had just done this assessment a few months earlier. And so the judge said that by failing to provide parent with notice of the previous assessments, which parents were obviously aware of, Simi Valley violated this provision of the California Code of Regulations and did not provide parent proper notice. And since the assessment plan wasn't proper notice, parent couldn't give informed consent. So the outcome of this case was that Simi Valley was ordered to fund 2 IEEs, one in speech and language and one in psychoed, because their assessment plan was defective. And like I mentioned, the judge didn't even look too much at the assessments. Our next case is the case of, I believe it's LA Unified, Parents versus LA Unified, Tillman. Parents versus LA Unified, so that means that the parents filed this due process case against LA Unified. In this case, parent was not represented by an attorney. LA Unified also was not represented by an attorney, but LA Unified did lose this particular case. The administrative law judge in this case was Chris Buchko. The due process complaint that the parent filed against LA was filed in May of 2025, and the hearing lasted for 2 days. I always like to look and see how long here. Some hearings are 1 day long. We have some cases today that the hearings were 10 days long. As you can see, this kiddo was 21 years old and had a number of disabilities. I didn't write this one down, but Lennox-Gastaut syndrome, which is a form of epilepsy, which is often accompanied by developmental delays and intellectual development. So the student was significantly impacted. As you can see, the student was nonverbal. But there had been a number of years where the parents wanted LA Unified to pay for this child to go to a non-public school. The non-public school was called Autism Academy. And for a period of about 5 years, LA Unified kept offering a program called Leichman, Leichman, which was their adult transition program. And for every 5 years, when the IEP meeting got together and LA Unified offered this Leichman program, the parent said, no, I want you to continue paying for my kiddo to go to this non-public school. For 5 years, LA Unified kept doing a settlement, funding this non-public school program. Finally, until this case, Los Angeles was like, we're not going to continue paying for this non-public school program. We want you to come back to our district. So they had an IEP meeting where they once again offered Leichman. What this case has to do with who goes to an IEP meeting and clear offers. As I mentioned, LA Unified lost the case. Why did they lose? Well, they had an IEP meeting where once again, they talked about this adult transition program called Leichman, and yet LA Unified did not invite any representative from Leichman. Now, LA Unified said, well, why would we invite anybody from Leichman? We don't have to. They're not a required IEP team member to invite someone from another program. We here at LA Unified can answer any of the mom's questions that she has about the program. Well, that's what they said, but then what the judge looked at was what actually happened during the IEP meeting. So they're having an IEP meeting where LA Unified's offering this adult transition program, but they didn't have a representative from the program. Parent had lots of questions about the program being proposed. And guess what? Staff did not answer the questions that parent had. Mom wanted to know, how are they going to work on the student's IEP goals? How are they going to provide services? What is the training of, how are they going to deal with the health issues, the seizure issues? And the staff from LA Unified said, those are great questions. I'm going to have to contact Leichman in order to answer those questions. So the judge didn't like that. The judge said the failure to have somebody from Leichman at the IEP meeting where the LA Unified staff were not able to answer all the parents' questions, denied the parent the ability to be able to know about the program. So that was a denial of faith. That was a procedural violation, which the judge found was a denial of faith. In terms of the clarity of the offer, as you can see here on the slide, there were two things that the judge said wasn't clear. I haven't been able to look at the IEP, obviously, but what the judge said in terms of the IEP was that there were, quote, two vague references about nursing, but that the IEP did not actually specify what those nursing services would include. So I'm super curious. I'm super curious if this IEP said nursing services, for example, 60 minutes per month. That's a frequency and duration, which is what the IDA requires. But did the judge want the nursing services to be specified? Like, would it include health issues? Would it include feeding issues? I'm curious what that was. And then PT was 300 minutes per year. Judges don't like these per year. In fact, the judge in this particular case quoted another Ninth Circuit case against LA Unified, which LA had lost when they didn't have a clear offer. And the judge said, by offering something per year, this means they could provide 290 minutes on the first day of the school and then 1 minute per day for the last few days of school. Or they could do 10 320 minutes per session, or they could just do 30 minutes per month. So the judge said that this is not a clear offer, right? When we do things per year. In terms of quoting that Ninth Circuit case, it's where LA Unified had offered services that were 1 to 10 sessions per week. And the judge said that wasn't clear. So we have to be clear about our offers, and doing it per year is not sufficient, nor is it sufficient to have a range 1 to 3 services. We are doing great. I know we're talking quickly, but hopefully you're getting some nuggets out of these cases. We have one last case to share with you. And it's the last case, Tillman, called Mill Valley. And as you can see here, it's parent versus Mill Valley. So it's the parent that filed this due process case. This case has to do with private school, parent seeking private school funding, and the parent in this case lost. This case was presided over by Administrative Law Judge Cynthia Fritz. Tillman and I have had her in a couple of hearings, and we've had favorable outcomes. And in this case, as I mentioned, Mill Valley did prevail in this particular case. So the due process case was filed in February 2025 by the student, and then Mill Valley cross-filed in March of 2025 to defend its own assessments. The hearing in this case was pretty long. It lasted for 8 days, and it took place in June of 2025, right around summertime. Usually we'd like to avoid hearings in summer when our staff is on break. There were a ton of issues in this case. Like Tillman mentioned earlier, the kitchen sink. We see these cases that we say, like, where an attorney like basically challenges every single part of the IEP, baselines, measurable goals, services, the placement offer, and that's what this case had to do with as well. And this kiddo had lots of diagnoses. As we see here, it was a super sad case, by the way. This kiddo was at a private school. I think it was called Marin Horizon. And the child saw his friend be killed at school on the playground when a rolling gate fell off of a truck and killed his friend. So the student in this case developed a significant, extreme fear of school. He was always worried that someone was going to get hurt. So very, very sad case. But as we can see in this case, on the next slide, with the one issue being what happened is because of the student's significant fears and school-based anxiety, the school district offered a therapeutic program that was a pretty small structured program to address the student's needs. And mom was like, no, I want my kiddo to stay at the private school. So even though at the hearing, the district's staff testified, our program is great. We have a really small program. There's only going to be like 5 to 8 kids in the class. It's therapeutic, it's social, emotional, embedded behavioral supports, all of the things the kiddo needed. And yet parents still wanted the district to pay for this private school. Well, the judge said, no, the private school does not have the supports the child needs. The school district has offered an appropriate program. So the school district prevailed in this case, and the public therapeutic program was found to be an offer of faith in the LRE. Those are our 8 cases covering all the things that we wanted to cover. And it's 12:44. We didn't have any chats. But for any of you that are our clients, if you have questions, feel free to email us. And I know that Tillman wanted to share some closing comments with you.
We have I should mention also, we have a chat in the Q&A function. So if you have any questions, please put those in the chat or feel free to email us. We're happy to answer those. We do have a couple of events coming up. We have our next Lunch with Legal, January 23rd, same time, 12:15. same price, which is free. You can scan that QR code to register. We also have a longer event, your kind of traditional in-person training called Onboarding Legal Insights. It's going to be on the Delta King in Sacramento. So hopefully that'll be fun and informative for everybody. If you have any questions, please let us know. Otherwise, we're so glad that you all could join us for this first Lunch with Legal, and I hope this was informative.
Thanks, everybody. Enjoy your weekend.